Welcome to the Deep Dive. Today we're really getting into a major work in legal philosophy. HLA Hart's The Concept of Law.
Yeah, it's a big one.
Definitely. And we want this deep dive to be, well, your focused audio study guide. We're aiming this specifically at you, the learner, to help you navigate this crucial text.
And we should mention this material is kindly made available to students by the University of London, strictly for educational purposes.
That's right. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. So for all of you getting ready for exams, seriously, good luck.
Absolutely. Our goal today is pretty clear, isn't it? We want to give you the best handle on how to approach Hart, understand his core arguments, and really nail that jurisprudence module.
We'll unpack the key ideas, look at his arguments, and figure out how to study this thing effectively.
Because, let's be honest, the concept of law can look a bit intimidating sitting on the shelf.
It really can. But understanding Hart is just, well, non-negotiable for jurisprudence. So many other thinkers, they either build on his work or define themselves by arguing against him.
He really is a cornerstone. And it helps to remember, Hart wasn't just locked away in an ivory tower.
No, he was professor of jurisprudence at Oxford, sure, but he had practical legal experience too.
Which really comes through, I think. His approach is often described as quite lawyer-like. Very careful with language, very attuned to the subtleties of how we talk about law.
Okay, so that's the background. Let's talk practicalities. You got the book. How on earth do you start studying it effectively? That seems like the first hurdle.
It really is. And the University of London materials give some great pointers here. The absolute key is to focus your most intense reading on the core chapters.
Which are?
The preface, definitely read that. Then chapters 1 through 6 and chapter 9, those are the ones you need to know inside out.
Preface 1 to 6 and 9.
Right.
Yeah.
Chapters 7, 8, and 10 are important too. Don't get me wrong, you should read them. But for really understanding Hart's main thesis, those core chapters are where you put your main effort. Build the foundation there first.
Okay, so preface 1 to 6, 9. Treat those like the main event. How do you actually, work through them? Just read cover to cover.
I wouldn't recommend that first time through. It needs a more methodical approach. Take it bit by bit, chapter by chapter, and make notes. Detailed notes as you go.
Notes are key.
Definitely. Think of each chapter. Maybe not just the core ones, but all 10, almost like a significant case you need to brief. Each one puts forward a specific argument or tackles a particular problem. You need to unpack that.
Treating each chapter like a case. I like that analogy. It makes it feel more manageable, less like this huge block of theory. What about the note-taking itself? Any specific advice?
Well, the UoL guide suggests aiming for maybe 4 or 5 pages of notes per chapter to start.
Wow, okay. That shows how dense it is.
It really is. Hart packs a lot in. You'll often find a whole crucial argument condensed into a single paragraph. So your first pass is about pulling those arguments out. Then maybe go back and summarize your own notes later.
Right, so it's not just highlighting, it's actively extracting the arguments. And the expectation for exams isn't just a vague idea of what he said.
Oh, absolutely not. You need to know his major theses in detail, and crucially, how he gets there, his methodology. What are his reasons for reaching those conclusions?
Understanding the how as much as the what.
Exactly. And the materials point out that his methodology, especially early on, can sometimes feel a bit ambiguous. So paying really close attention to his discussion of definition in Chapter 1 is vital. It sets up how he approaches the whole thing.
Okay, focus on the methodology, especially that early discussion on definition. And we shouldn't just read Hart in isolation, should we?
No, definitely not. You need context. The materials rightly flag Ronald Dworkin's famous criticisms in taking rights seriously. And Hart's own response in the postscript to later editions is also really important, though that connects more directly to later topics, like Topic 9 on adjudication. But keep Dworkin in the back of your mind as you read Hart.
Right. Think about the debate. Okay. Study strategy seems clear. Core chapters first. Preface 1 to 6, 9. Methodical reading. Detailed notes. Focus on arguments and methodology. And be aware of critics like Dworkin. Let's dive into the content itself. What was Hart actually trying to achieve with this book? His main aims?
He tells us right in the preface. He calls it an essay in descriptive sociology. And understanding what he means by that is, well, job number 1.
Descriptive sociology. It sounds a bit grand, maybe slightly misleading. Because it's not like he went out doing surveys, is it?
No, not at all in the empirical sense we usually associate with sociology. It's descriptive in that he wants to describe our shared understanding, our concept of law. He sees law as a social phenomenon.
Okay, describing a social thing. What are the assumptions there?
The UoL materials highlight two big ones. First, he assumes there is a shared concept of law out there to be described. Second, he thinks discovering it is mainly a matter of careful description, not judging it morally or making political arguments about what law should be.
Descriptive, not evaluative or prescriptive. But that sociology label still feels a little odd without the fieldwork.
It does, I agree, but think about how he's doing the description. He's not counting heads. He's looking incredibly closely at language.
Ah, the linguistic focus we mentioned earlier.
Exactly. As the UoL materials explain, he believes that by carefully examining the way we use words connected to law, words like obligation, rule, right, validity, we can understand the social reality they reflect. It's like using language as a lens to see the social phenomenon.
The language holds the key to the social reality.
Yeah.
And the preface also introduces another absolutely massive idea, doesn't it? The different points of view.
Yes, the internal and external points of view. This is fundamental. You absolutely have to grasp this distinction.
Okay, break it down for us.
The external point of view is just observing behavior from the outside, seeing patterns, like noticing that cars usually stop at red lights.
Okay, the observer's view.
Right. But the internal point of view is the perspective of someone within the practice, someone who accepts the rules as reasons for acting, as standards to follow. For them, the red light isn't just a predictor of traffic movement. It's a reason, a standard, for stopping.
So it's about acceptance of the rule as a guide.
Precisely. And Hart argues you can't truly understand a social practice like law, which is built on rules, without understanding this internal perspective. This idea is critical for his whole analysis of rules later on.
Internal acceptance versus external observation. Got it. Seems like a lens we need to keep on throughout the book. Okay, chapter 1. He starts by talking about why defining law is so hard. Why not just give us a definition?
Well, he first identifies these three big persistent questions in jurisprudence. One, how does law differ from just being forced to do something, like orders backed by threats? Two, what's the connection between legal obligation and moral obligation? And three, what does it even mean for a social rule to exist?
Right. The big question.
And he argues that the reason a simple definition of law is so elusive is that no single formula can really capture the complexity needed to answer all those questions across all the different things we call law.
And he gives examples of these tricky cases.
He does. He points to what he calls the difficult cases, or borderline cases. Think international law, it lacks a central legislature, courts with compulsory jurisdiction, centrally organized sanctions. It looks quite different from domestic law. Or think about primitive law in simpler societies. Maybe no formal courts or legislatures at all. A definition designed perfectly for, say, the UT legal system might just exclude these other things we still often refer to as law.
So trying for a one-size-fits-all definition is bound to fail because law itself is so diverse. Okay, if not a simple definition, what's Hart's alternative strategy?
Instead of a rigid definition, he decides to build a model. He focuses on what he sees as the central set of elements in a standard, clear case. The modern municipal legal system, your typical national legal system.
Like the UK or France or the US.
Exactly. He aims to identify the core features of that, which turns out to be the union of primary and secondary rules. And then, once he's built this model of the clear case, he can use it as a kind of benchmark.
A benchmark for comparison.
Precisely. To compare those difficult cases, like international law or primitive law, against, to see how they are similar and how they differ. It allows for nuance, rather than a simple yes-no on whether something is law.
That makes sense. Build a clear picture of the core, then see how other things relate to it. And the ULL notes mention he comes back to international law later on.
Yes, in Chapter 10. After he's fully laid out his model of primary and secondary rules, he circles back to international law to apply his framework, showing its strengths and perhaps limitations in explaining that particular phenomenon. He deliberately avoids the upfront definition to allow for this more nuanced comparative analysis later.
Okay, strategy noted. Now, chapters 2, 3, and 4 are pretty famous. They're Hart's big critique of the orders backed by threats theory. For someone studying for an exam, what's the absolute core takeaway from this critique?
The absolute heart of it, as the UoL material stress, is that the orders backed by threats, or OBT theory, which we strongly associate with John Austin, completely misses the idea of rule following. It reduces law to commands and fear.
Just being forced to do things.
Right. Hart says this totally fails to capture the normative aspect of law, the way law creates obligations, gives us reasons for acting, guides our conduct from that internal point of view we talked about. It's not just about predicting punishment.
There's a felt difference between being forced and having an obligation. Chapter 2 uses language to highlight this, right?
Exactly. He uses his linguistic method. He draws that famous distinction between being obliged, that's the bank clerk forced by the gunman to hand over money, and being under obligation, like having a legal duty to pay taxes.
Gunman versus tax inspector.
Precisely. Being forced, obliged, doesn't create an obligation in the sense Hart is interested in. Our language reflects this crucial difference.
So our words reveal the concept. Then Chapter 3 takes this OBT ideal of law is just commands from a sovereign backed by threats and attacks it on a larger scale.
Yes, he offers three main criticisms of seeing law as just orders writ large. First, he says the OBT model is fixated on duty-imposing rules, the do this or else's type, and completely fails to account for a huge category of laws. Power-conferring rules.
Rules that let us do things.
Exactly. Rules that give us the power to make contracts, write wills, get married, create companies. These aren't commands backed by threats. They're recipes for creating legal rights and duties.
That seems like a massive oversight by the OBT model. What's the second critique?
Second, the OBT model struggles with the fact that in many legal systems, the laws apply to the lawmakers themselves. The Queen in Parliament or Congress, they are bound by the laws they make. The OBT model pictures a sovereign who stands outside the law, just issuing orders.
Which doesn't fit modern constitutional systems. And the third point.
Third, the OBT model implies that every law has a specific moment of creation, a deliberate command. But that doesn't really fit all types of law, does it? Think about common law, evolving through judicial decisions over centuries, or local customs that are legally recognized from time immemorial. They weren't necessarily ordered by a specific sovereign at a specific time.
Right. Customary law and common law don't fit that command model easily. Okay, so OBT fails on power-conferring rules, laws applying to lawmakers, and the origin of some laws. Then Chapter 4 attacks the OBT idea of the sovereign itself.
It does. The OBT theory defines the sovereign as the person or body who is habitually obeyed by the bulk of society and who doesn't habitually obey anyone else. It's about brute facts of obedience and power.
A habit of obedience.
Yes. And Hart argues this struggles badly with the continuity of law. Think about his Rex Mar and Rex II example. When Rex Va, the ruler everyone obeyed, dies, how does his successor, Rex II, instantly have the right to rule? There's no established habit of obeying Rex II yet.
The transition of power problem.
Exactly. Hart argues that what ensures continuity isn't habit, but rules. There are rules that confer the right to succeed, rules that determine who the sovereign is. The OBT model, focused on habits, misses this rule-based nature of succession and authority.
So it's rules that create the office, the authority, not just the fact that people happen to obey someone.
Precisely. And he also points out that the legal sovereign is often not a single person, but a body, like Parliament. It's a legal construct, defined by rules, not just a person people fear.
Right.
The OBT model overlooks this corporate, rule-defined nature of sovereignty.
Okay, so the OBT theory is pretty thoroughly dismantled by the end of Chapter 4. This then perfectly sets up Hart's own positive theory in Chapters 5 and 6, the union of primary and secondary rules. What's the big picture here for students?
This is it. This is the absolute core of Hart's positive contribution in the concept of law. It's his answer to the problems he found in the OBT theory. If you understand this union, you understand the heart of Hart's theory of law.
So let's break it down. Chapter 5 starts with imagining a society without this union, right? Just primary rules.
Yes, he paints a picture of a hypothetical pre-legal society. It only has primary rules, basic rules imposing duties, like don't steal, keep your promises, don't use violence. These are rules about conduct.
Sounds simple enough.
Yeah.
But he says this society would have problems.
Major problems. He identifies three key defects. First, it would be static. With only primary rules, there's no recognized way to deliberately introduce new rules, change existing ones, or get rid of old ones. Rules would only change very slowly, through custom.
Okay, defect 1, static rules. What else?
Second, it would be inefficient. If there's a dispute about whether a rule was broken or how it applies, there's no official body with the authority to definitively resolve the dispute or enforce the outcome. Think vendettas and self-help.
Inefficiency in application and enforcement. Got it. And the third defect?
Uncertainty. In a complex society with just primary rules, how do you know for sure what the rules actually are? Which rules are the rules of our group and which aren't? There's no authoritative text or person to point to.
Static, Inefficient, uncertain. Sounds pretty bad. So how do secondary rules fix this?
Secondary rules are the remedy. They are crucially rules about the primary rules. They don't impose duties directly on conduct, but they confer powers related to the primary rules.
Powers to do things with the primary rules.
Exactly. Hart identifies three types. To cure the static defect, you introduce rules of change. These empower specific people or bodies, like a legislature, to introduce new primary rules and eliminate old ones.
Okay, rules of change fix the static problem. What about inefficiency?
That's addressed by rules of adjudication. These empower individuals or bodies, like courts, to make authoritative determinations about whether a primary rule has been broken in a particular case, and often to direct the application of sanctions.
Courts and judges. Makes sense.
Yeah.
And the big one, uncertainty.
That's cured by the most important secondary rule, the rule of recognition. This rule specifies the criteria that a primary rule, or indeed another secondary rule, must meet to be considered a valid rule of the system. It provides the authoritative test for identifying the law.
So the rule of recognition tells you how to spot a genuine law in your system. Like what the Queen and Parliament enacts is law.
Exactly. That's the classic example for the UK. This union of primary rules of obligation and these three types of secondary power-conferring rules is, for Hart, the very essence of a developed legal system. It's what moves a society from that pre-legal state to having law.
And Chapter 6 zooms in on this rule of recognition.
It does. Chapter 6 really digs into the nature and function of the rule of recognition. It connects it to ideas of legal validity and the foundations of a legal system often found in constitutional law.
And this is where his positivism really comes to the fore, right? How the rule exists.
Absolutely crucial point. The University of London materials rightly emphasize this. Hart argues the existence of the rule of recognition is ultimately a matter of social fact. It exists because it is actually accepted and used as a standard by the officials of the system, primarily judges, but also other senior officials.
It's about what they do and accept, not necessarily about whether it's morally good.
Precisely. Its existence isn't validated by some higher law or moral principle. It's shown by the actual practice of the officials who identify and apply the law according to its criteria. This is central to Hart's separation of law and morals.
And this links back to the internal point of view.
Yes. The officials must accept the rule of recognition from the internal point of view. They use it as a common public standard for assessing their own and others' official actions.
Okay, so combining these ideas, when can we definitively say, according to Hart, that a legal system exists?
He gives two minimum conditions. First, the primary rules identified by the rule of recognition must be generally obeyed by the bulk of the population. The law needs to be, by and large, effective.
So people generally follow the basic rules.
Right. And second, the secondary rules, especially the rule of recognition, but also rules of change and adjudication, must be accepted as common public standards of official behavior by the system's officials.
Effectiveness among the populace and acceptance by the officials. That's the two-part test. Got it. Now, you mentioned Chapters 7, 8, and 10 can perhaps be read with slightly less intensity initially, especially for exam prep. Can you give us the quick headlines for those?
Sure. Chapter 7 is about legal reasoning. Hart discusses the open texture of language, the fact that rules have a core of clear meaning but also a penumbra of uncertainty, where judges inevitably have to exercise some discretion. He uses this to critique some versions of American legal realism that were perhaps overly skeptical about rules.
Okay, open texture, judicial discretion. Chapter 8.
Chapter 8 tackles law and morality directly. This is where he defends his positivist thesis, the conceptual separation of law and morality. He discusses different ways law and morality connect, introduces the idea of a minimum content of natural law based on human nature, but ultimately insists that a rule's legal validity doesn't depend on its moral merit.
The separability thesis.
Oh, yeah.
In Chapter 10.
As we said, Chapter 10 revisits international law, applying the primary-secondary rule framework to see how well it fits and what it reveals about the nature of international law compared to domestic systems.
Okay, useful additions, but the core engine is definitely due. Chapters 1 through 6 and 9. Let's loop back to that internal point of view and acceptance by officials. The UoL materials hint this isn't as straightforward as it sounds.
It's definitely more complex. Hart says officials accept the rule of recognition, but why do they accept it? Is it moral approval? Self-interest, tradition, inertia. Hart doesn't fully specify, focusing on the fact of acceptance rather than the reasons for it.
And this is where people start to critique his theory, like Perry, who the UoL guide mentions.
Exactly. Critics like Stephen Perry question whether Hart can truly maintain a purely descriptive stance. Perry argues that by choosing the modern municipal legal system as the central case, Hart is already making an implicit evaluative judgment about what counts as a developed or paradigm legal system.
So maybe description isn't totally neutral.
That's Perry's point. He also argues that just saying officials accept the rules doesn't fully explain the normativity of law, why rules are seen as creating genuine obligations or providing reasons for action. Perry suggests you might need to bring in moral or other evaluative arguments to explain that, which is exactly what Hart wanted to avoid in his descriptive project.
So the why of acceptance remains a tricky point. Okay, one last big theoretical piece. The discussion on following rules, bringing in Wittgenstein. This sounds deep.
It is, and it connects back to the open texture idea.
Yeah.
The UoL guide points to Hart's contrast between just acting habitually and genuinely following a rule. Rule following involves this shared understanding, using the rule as a standard, social pressure, criticism for deviation.
Right, not just coincidence of behavior.
Exactly. Then it brings in Wittgenstein's paradox, often illustrated with learning chess or extending a number series. How do you know you're applying the rule correctly in a new situation you haven't encountered before? The rule itself, written down, doesn't seem to contain all its future applications within it.
That chess example is mind-bending. Like, how do we know the bishop doesn't suddenly move like a knight after your 25th birthday? The initial rules didn't explicitly forbid that.
Precisely. It highlights the gap between a rule formulation and its application in practice. This led some thinkers, the rule skeptics, to argue that maybe rules don't really constrain judges much at all. Maybe judges decide first and just find rules to justify the outcome.
But Wittgenstein wasn't saying rules are useless, was he?
No, not at all. His point was different. Following a rule isn't about having a perfect mental algorithm. It's more like a practical ability, a knowing how, embedded in a shared form of life, a shared practice. We learn to go on in the same way based on shared judgments of similarity and difference within that practice.
So it's about being part of the game, the shared understanding.
Yes, and this resonates with Hart's core and penumbra idea. Rules work clearly most of the time, the core, because we share judgments within our legal practice. But at the edges, the penumbra, where things are less clear, applying the rule requires interpretation and judgment, drawing on the shared understanding of the rule's point and context. It's not mechanical, but it's not arbitrary either. Following a rule depends on this backdrop of shared practices.
Okay, so rule following is a social practice, not just individual calculation. Well, okay, we've covered a huge amount of ground on Hart's The Concept of Law. For our listeners facing exams, let's try to boil it down. What are the absolute must-remember key takeaways?
Okay, essentials. 1. Hart's core idea, law as the union of primary rules, duties, and secondary rules, powers change, adjudication, recognition. 2. The absolute centrality of the rule of recognition as the ultimate test for legal validity, existing as a social fact based on official acceptance. 3. His powerful critique of the orders backed by threats theory for missing normativity and rule following. 4. The importance of the internal point of view understanding law requires seeing it as providing reasons for action for those who accept it.
And be ready for criticisms.
Yes. Be aware of challenges like Perry's questions about whether the theory is purely descriptive and the philosophical complexities around rule following highlighted by Wittgenstein and the rule skeptics, which connect to Hart's ideas on open texture and discretion.
Fantastic summary. And as the University of London materials imply, even if you end up disagreeing with Hart on some points, grappling with his arguments is just essential training for thinking seriously about law.
Couldn't agree more. It really forces you to clarify your own thinking on these fundamental questions. It's a challenging read, no doubt, but incredibly rewarding.
So maybe a final thought for you, the listener, to take away and chew on. Think about that distinction Hart makes between being obliged, the gunman, and being under an obligation, the law. How does that play out today? When we encounter state power, are we merely being obliged or are we genuinely under an obligation? What makes the difference?
That's a great question to reflect on. What does it really mean to have a legal duty versus just being compelled? Hart gives us a framework, but applying it is where the really interesting thinking happens.
Absolutely. Well, we really hope this deep dive has given you a clearer path through Hart's complex but vital work. Remember the advice. Read actively, make notes, engage with the arguments. We wish you the very best with your studies and, of course, with those exams.